So my name's Chris Pelkey. I'm a labor and employment lawyer, and I work at McInnes Cooper's Fredericton office. And I'll let my partner here introduce himself.
Thanks, Chris. Hi, folks. My name is Alex Warshick. I'm a partner in our Halifax office, also practicing labor and employment. Do a little bit of everything in terms of labor and employment, but with a bit of a specialization in particular in the construction industry.
So to go over a kind of bit of an agenda here, this one's going to be kind of heavily focused on the new changes to New Brunswick's Human or Employment Standards Act, introducing a new long-term illness and injury leave. But we're also going to go over some things that are going to be of general interest to people in other provinces who've joined us here today, including things on duty to accommodate. And then we're also going to go over similar leaves that exist in other provinces, Nova Scotia, PEI, and Newfoundland. We're kind of focusing the first part on New Brunswick here because it's a brand new leave that's been introduced here. And I think that a lot of you who've joined us today who are in New Brunswick probably may not have been aware or may have heard that this change came down the pipeline and probably are looking for some additional information because it does kind of change the employment and labor landscape in New Brunswick a little bit. So the new bill, in this case, is Bill 26, and what it did is it introduced a new illness and injury leave in New Brunswick, and that bill has since received royal assent, and the changes have been made to the Employment Standards Act. So if anybody wants to kind of follow along with this or read through the text themselves, you can open up the Employment Standards Act and go to section 44.029, and you'll see the kind of text of the provision that we're going to be talking about today. So to give you a bit of an overview of what this leave entails, so it's a brand new leave, and it offers employees up to 27 weeks of unpaid leave in any 52-week period. It has a qualifying period, so an employee has to be employed with you for at least 90 continuous days of employment before they could take advantage of the leave. And it's designed for employees who are incapable of working due to, and this is the language that they've used, long-term illness or injury. And so New Brunswick is actually one of the last provinces to introduce this type of leave in its employment standards legislation. And in kind of typical New Brunswick fashion, we waited until other provinces did it. We saw what did and didn't work with those other provinces, and then we ignored all that and just copied their language anyway. So one thing that you'll find is that our language actually mirrors the language in a lot of other provinces, which is a little bit unfortunate because there have been some problems that have come up in those other provinces.
I think
So,
just if I can hop in, there's going to be no real surprise, like Chris has just said, that when we get to Nova Scotia, PEI, and Newfoundland at the end of today's presentation, you're going to see very similar wording, very similar language, and similar lengths of leave. And you may be asking yourself, well, why 27 weeks? Well, the 27 weeks is meant to mirror the sick benefits that you can get under EI. So you can get 26 weeks of sick benefits under EI, and then the 1 week of the waiting period. So that's why when you look at all these pieces of legislation, whether we're talking New Brunswick, PEI, Nova Scotia, Newfoundland, you're going to see 27 weeks, and that's to match up with the EI period.
So to give you an idea of what the leave actually looks like in this case, employees are allowed to take the leave all at once, so they can start it and they can take it 27 weeks start to finish, or they can break it up into separate periods. So they can take a week at a time, come back for a period, take another week at a time, come back for a period, so on and so forth. The only limiting factor here is that it is a maximum of 27 weeks in any 52-week period. So that's what you're going to want to be tracking as an employer. If an employee is taking a full leave, it should be pretty easy. Otherwise, you're going to want to make sure that you're maintaining very accurate documentation of when they started a leave period, when the leave period ended, how long the break between periods was, because this is going to be really important for administering these types of leaves in your organization. The other kind of caveat here is that each period the employee takes has to be at least 1 week long. So they can't use this leave to cover absences of a day or two. So when you're looking at the legislation in New Brunswick, if somebody wants to take an absence of a day or two, then it's going to fall under our regular sick leave protection. That's not what this leave is for. This is for illnesses and injuries that are expected to have a longer duration, not kind of one-off illnesses if somebody has the sniffles or that kind of thing. And then the final thing is that the act actually defines a week. So a week runs from midnight Saturday until midnight Sunday. So it's a calendar week and kind of what everybody would expect. So this isn't a thing that employees can kind of spring on employers out of the blue. The act does provide employers with a little bit of protection here, in that the employee must advise the employer in the language that they use again is without delay. And they have to give employers notice of their anticipated start date and anticipated duration. So they have to say to the employer, look, I'm having a medical problem, I'm experiencing illness or injury, I'm expecting to start being off work on, Thursday, June 25th, and I'm expecting to be able to come back to work 3 months later or 4 months later or what have you. The other thing to remember here is that the return date that they specify is not set in stone. So employees can extend the leave and extend the return date during their leave. But again, they've got to notify the employer. They've got to give you a new updated return date, and they have to keep the correspondence open. So they can't just, on the day they're supposed to return, come back and say, oh, sorry, no, I'm not actually coming back. I'll see you. Oops. I'll see you. Lost my slide here. So they can't just say, look, I'll see you 3 months later. They have to give you an update if they do want to extend. And then kind of the final thing is that employers are entitled to request a medical certificate justifying the leave. And the act actually specifies the types of practitioners that you can request a medical certificate and really have to accept a medical certificate from. So the first is medical practitioners. That's your family physicians, walk-in clinics, emergency rooms, private healthcare providers, that kind of thing. The second is a nurse practitioner. And then the third, they actually allow certificates from midwives. And again, that would probably usually only relate to maternity-related illnesses or injury. The legislation in this case, and I noticed there were some questions that came in through the email about job protection. So in this case, the legislation does include job protection when the employee returns. And so it says that the employee has to be reinstated to the same or a comparable position. So you don't have to give them their exact position back, but it has to be a position that's comparable. And again, the act doesn't define this, but looking at the experience in other provinces would really be comparable in terms of the level of responsibility, level of seniority, the level of prestige, for lack of a better word. It's got to be a position that's comparable to what they were doing before, kind of on the same level. And they have to be returned with no reduction in pay. So even if you move them to another comparable position that typically pays slightly less, you're going to have to maintain their previous salary. And there's no loss of any other benefits that they accrued prior to the leave. So if they've accrued vacation pay and time off prior to the leave, it's not like that disappears when they return to work. That would be reinstated, and they would be entitled to all the regular entitlements that they would have had they not gone on the leave. The other piece here is under New Brunswick's Employment Standards Act, there are actually additional leave protections that apply to any protected leave that an employee could take. So these have been there for years. They're the ones that most employers are kind of normally used to seeing, and they do also apply to this long-term illness and injury leave. So in addition to having to return the employee to their previous or comparable position, you're also going to have to look at these general protections. And so if you're following along in the Act, these are found at section 44.04. And kind of the two big things here is that they have reprisals protection, and they have protection for continuity of service, so preservation of seniority. So the first thing that the Act says in section 44.04 is that an employer shall not discipline, suspend, terminate, lay off, etc., an employee during a leave of absence or for any reason related to the leave of absence. Um, Now, there's some case law in New Brunswick that says, look, if an employee is on a leave of absence and you've restructured and their position's eliminated, or something's happened that's totally unrelated to the leave that would have prevented them from continuing their employment, that you can actually go ahead and you can terminate, notwithstanding what this section says. In this case, where this leave is dealing with illness and injury, I would be cautious in kind of following that approach. And I think it would be better for most employers to treat that protection as absolute. The reason being, when you look at the leave or when you look at the termination provisions in the Employment Standards Act and the termination principles that have been developed by our courts, they're generally there to give employees an adequate period of time to go and find another job. And so I think that when you're dealing with a leave like this, where the person is medically unable to work due to an illness or injury, it's not quite the same, right? If you're giving them advance notice, they have to actually be able to go out and get a job. And if they're not medically able, then they can't go out and get a job. And so the whole purpose of the protections fail. So I think in respect of other leaves, there is some support out there for being able to end employment mid-leave due to something unrelated to the leave. For this leave, I would be a little bit more cautious in taking that approach, just given the nature of what this is dealing with, and given the fact that this is relatively new, and we're not quite sure how the employment standards section of our PEDAL is going to address this, and we're not quite sure how the courts are going to address this.
Yeah, just throw in my 2 cents there is that, when you're dealing with somebody who's ill or disabled, whether it's permanent or temporary, and putting aside the statutory protection of this particular leave, termination in those circumstances, even if it is for and hopefully it is for some other reason, some other good reason, it's very hard to avoid the immediate implication or the immediate appearance that it is related to their being off or they're having this condition of being unable to work or unable to perform their duties. So you're in a bad situation to be attempting to terminate, even if it is due to X, Y, or Z. Very valid reason. You have the appearance of termination for disability or for illness, which under human rights, you're going to be in a difficult situation to defend that termination were they to make a human rights complaint.
That's a really good point that Alex raises and we'll get into this a little bit later in the slideshow, is that this leave does not replace your obligations as an employer under the human rights legislation in your province. And generally, in all provinces, there's a presumption of discrimination if somebody's terminated during a leave. So if you terminate someone during a leave, it's automatically presumed it's discriminatory, and then you have a fairly high hill to climb over to prove that it's not discriminatory. So in this case, like I say, I would really encourage employers to treat this cautiously and to avoid any terminations while an employee is on leave. Because again, I think that the justifications are different for this one. The last piece here is that it does protect continuity of service. So in terms of any entitlement or right, whether that be an entitlement under the Employment Standards Act, like vacation or notice on termination entitlements, or an entitlement under the employment contract that is tied to length of service, it's going to preserve that length of service during the leave. So you don't pause accruing seniority just because somebody takes advantage of this. They're going to continue accruing seniority throughout the leave until they're back, and then they'll continue as normal. So this is just kind of going through the additional statutory protection. So we talked about the no discipline or termination due to leave. It also applies despite operational challenges. So this would really take into account the situation where an employee is returning to work following a leave, it's going to be difficult. You're going to run into scenarios where you may not have a position available. You're going to run into scenarios where you may have to reassign somebody who has been brought in to backfill their duties. There's a number of different scenarios that could happen that are going to make returning an employee to work after a leave like this operationally difficult. The Employment Standards Act does not care or consider that as a factor at all. You're expected to endure some operational difficulty, and you've got to go through that, and you've got to make a genuine attempt to return somebody to work. The limited exception to this is where the termination is unrelated to the leave. And so again, that's the case where the employee works in a department that's been eliminated while they were on leave. So what would happen in that case is when the employee was ready to return, you would meet with them. You would say, look, we would have liked to return you to work. We've examined our operations. We have no other place to put you. And unfortunately, your position was eliminated due to reorganization or elimination of the department or whatever. And in those cases, you're not going to get caught by the statutory protections because they do include this exemption. Again, seniority continues to accrue. So if somebody would have, for instance, in New Brunswick, the cutoff for vacation increases is 8 years. At 8 years of employment, an employee's vacation entitlement under the Employment Standards Act increases. And so if they would have crossed that threshold while they were on a leave, then they are entitled to that benefit. And then this is the part that I think Alex and I were kind of talking about. And when I looked through the questions that we've already received on this is really what I think most employers are struggling with. And I think it's fair. At this point, employers have essentially been told, and I'm sure you've all heard it before, you've got a duty to accommodate employees to the point of undue hardship. And there's been very little guidance provided outside of that. Essentially, what the courts and human rights commissions and tribunals have told people is, well, you got to look at each circumstance individually, and no two situations are the same. And so it's very difficult to come up with a rule that's going to apply consistently in these circumstances. And I think that is causing a lot of frustration for employers. But the important thing for the sake of this leave is that the 27-week leave under the Employment Standards Act does not replace your duty to accommodate an employee under human rights legislation. That's an independent duty. It exists independently of this leave. And I would actually say sits on top of this leave and will actually create additional or may create additional obligations with respect to these employees. And so one of the key things to remember about this is that after the employee exhausts their 27-week leave under the Employment Standards Act, that doesn't mean that they have to return to work or else they're fired. At that point, you're into the normal duty to accommodate assessment. You're into the normal assessment of whether or not the employee is medically able to return to work, what accommodations are required, and if not, and again, this is what a lot of the questions came down to, how long can the employee stay off before you can actually end the employment relationship? So Alex, did you want to kind of add some comments on this?
Well, I don't want to spoil the Q&A for one. So just to let folks know, we do have a handful of pre-submitted questions that we're going to address at the end. But we don't have a particularly long presentation today, so there's plenty of time for questions at the end, which we know generally you folks find the most useful part of these presentations. So do encourage you to use the Q&A button in Teams, put your questions in. We'll take a look at them at the end. But we are going to talk about frustration and return to work. In particular, we received a number of questions on that. So why don't we finish our pre-canned presentation, and then we'll start to address those before we go too far off into a tangent on that.
Sounds good. And then the last piece that you're going to want to keep in mind is that the new leave actually preserves rights that employees have under the Workers' Compensation Act. And this is explicitly set out in section 44.029. And so what it says is all of the rights, entitlements, obligations under section 42 sub 3 and 42 sub 4 of the Workers' Compensation Act will continue to apply. And so for reference, the illness and injury leave in this case is going to apply to any illness and injury, whether it occurs at work or outside of work. The workers' compensation rights that we're talking about here are only going to apply to employees who are injured while they're at work. And so the two main ones that you're going to want to keep in mind is that under the Workers' Compensation Act, there is actually an additional prohibition on terminating an employee who's off work receiving workers' compensation benefits. And in New Brunswick, I forget what the exact numbers are, but what you're going to look at is your number of employees, and I think it's set at 20. And so if you have fewer than 20 workers when the employee goes on leave, then you have to essentially keep their employment going for at least 1 year. And if they have more than 20 workers, then it goes to 2 years. The other kind of important piece here is that employers under the Workers' Compensation Act have an obligation to work with the employee and WorkSafe MB to ensure a safe return to work. And so regardless of what happens with their employment standards leave, with this 27-week leave, you are still going to have to meet your obligations to the employee and to WorkSafe MB to try and return them. And again, these protections that we're talking about are only going to apply to employees who are injured at work.
Right. It's a serious complicating element, though. Typically, if it's out of the course of employment that the person has become ill or injured, we're talking about then, these protected leaves that we've been presenting on so far. We're talking about human rights duty to accommodate. So you've got two sets of legal obligations, but when the injury has occurred or the illness has occurred in the course of employment, then we've got this third element, and a lot of the questions that we have received. So maybe I'll do a little spoiler here. A lot of the questions we have received, they may relate to injuries that have occurred at work or in the course of employment, or illness that's occurred in the course of employment, and that's going to trigger that obligation if you're over 20 employees. For 2 years. In Nova Scotia, it's 2 years from the date of the injury that you have to re-employ that person. So, they may have been off for a significant period of time. They may have, access to LTD and workers' compensation, but, there's still a clock ticking to re-employ if it's an injury that's occurred in the course of employment.
Yeah, it's a bit of a kettle of fish in that you've got, 3 pieces of legislation that are all giving employees rights to take these leaves and rights to get their job back, and they're imposing additional duties on employers, and they all kick in at different points, and they all have different requirements. And so it's a very, very challenging landscape, and it's a big boiling kettle of fish that the province has basically handed to employers, and they've said, you guys deal with it and figure out what to do. It's very frustrating. It's very complex, but if you do it right, you can come out the other end relatively unscathed. Kind of the last piece that I would just add on to this before we kind of move on to the other provinces, as I mentioned earlier, what New Brunswick did here is we basically copy and pasted language that's been used in other provinces for these types of leave, and we've kind of done it without much regard for the difficulties encountered in those other provinces. And so I think that the biggest difficulty that I've seen when I've been looking at this across Canada, and particularly in Manitoba, is that this leave applies to injury and illness. And injury and illness are not defined in the legislation. So I think the question has come up a lot. Well, what qualifies as an injury or illness? If somebody is, if somebody's breaks their leg, I think that's very clear that that's an injury. If somebody's dealing with Lyme disease that lasts months, it's fairly clear that that's an illness. But where employers have been struggling with this is things like mental disability, depression, anxiety, and that kind of thing, and neurodivergence, ADHD, learning disabilities, and that kind of thing. And the question that they've all had is, well, is a mental disability or is neurodivergent an illness or injury? Because on our understanding of those terms, it really isn't, right? Their disabilities are something totally different. An illness is typically something you're going to recover from, as is an injury. And I think in the practical experience of employers and lawyers working in those other provinces, the way that they've treated this is if an employee has some sort of a medical certificate supporting that they need to be off work, regardless of the reason, you're going to have to treat it as falling under the scope of the protections in this. So you can debate whether or not mental disability or neurodivergence is an illness or injury, but I think at the end of the day, and based on experience in other provinces, and particularly Manitoba, I think that what you're going to find is, look, if they've got a medical note saying that they're qualified to be off work for a medical condition, it's going to meet the requirements under this act. So I think Alex is probably the best guy suited to talk about Nova Scotia. So. Oh, I think you're muted, Alex.
I was just laughing. I get to do my 3 slides before we get into our Q&A. So there's not a lot of surprises in the legislation in Nova Scotia, PEI, or Newfoundland, based on what Chris has already presented on for New Brunswick. What you're seeing is an entitlement to a 27-week leave. Again, it can be one continuous period. It can be multiple periods. I believe it's up to 4 periods over a 52-week period. So you could break it up into a number of chunks. And in Nova Scotia, the requirement is that the employee give the employer notice as soon as possible in writing that they're going on this leave or that they require this leave. And so in some instances, the employee may not be able to do that until they've already, sustained the injury or the illness. I don't think it's a hard and fast rule, and I don't think that's the case in any of these provinces. If the employee's in, for example, a car accident and it's very sudden, obviously they're not going to give you advance notice of it. There's not strong expectations around notice here. It's as soon as possible from the employee, but there is a prescribed form that Labor Standards has put out that the employee is to fill out. The employee fills out sort of a notice to their employer, a description of their duties, and then there's a second page on the form which they're to give to a medical practitioner who is to provide some medical information about their illness or injury and their inability to perform their duties. So you can actually find that online if you look up. It's called the notification form to employers for serious illness leave. And you can find that online and take a look at that. And so if you do have an employee looking to access this leave, you can give them this form that they can use and have filled out both. They have to fill out the first page, and then a medical practitioner fills out page number 2. So this all took effect just last year, January 1 of 2025, part of the Stronger Workplaces for Nova Scotia Act. That's also the act that brought in some additional unpaid sick days, and then the additional unpaid days for medical appointments for employees or for their immediate family members. So all part of that change that came in last year to the Labor Standards Code. Chris, do you mind advancing the slide there? So PEI, not all that dissimilar from what I just described in Nova Scotia. Likewise, 27-week leave. So you're seeing all of these, like I said at the start of the presentation, as 27 weeks, and that's to match up with the EI sick benefits that are provided through employment insurance. What you'll see in terms of the language in PEI, and this is all coming into effect in just a few days, actually. So the new ESA is coming in on June 30th. And what you'll see is language very similar to what Chris has described in New Brunswick, with the notice expectation similar to Nova Scotia, which is as soon as possible that the employee provide written notice of their intent to take this leave or requirement to take the leave. So nothing all that new from what we've talked about in New Brunswick or Nova Scotia. And last, certainly not least, Newfoundland. So Newfoundland was the first to put this kind of language in. through an amendment in 2024. Again, we're seeing a 27-week unpaid leave entitlement within the year period. There is an expectation in the notice to the employer that there be a specific start and end date provided. Obviously, I would expect that the end date may be a moving target depending on the condition, the illness, the injury, and sort of the prognosis. There's a further leave of up to 104 weeks if the injury is caused by a criminal offense. And interestingly, in Newfoundland, back in PEI rather, there's explicit reference to organ donation, and there is also in Newfoundland explicit reference to organ donation. So you can also take this leave off if you are an organ donor, for example. That might be a reason to require to take the leave.
And I think for PEI, just to add in, I think there's also an explicit reference to gender affirming care as well. So if somebody is going through gender affirming surgery or any related procedures, then they would be able to take advantage of the leave in PEI. And I suspect, I mean, in New Brunswick, they don't list that as they don't explicitly list gender affirming care or procedures. But I would suspect that it would be included under the very broad definition of long-term illness and injury.
Yeah, and I suspect that the same argument would be made in Nova Scotia that if you're off because you've had surgery to give to give an organ, for example, that's going to be a serious injury under the act, or if you've undergone gender affirming surgery. Absolutely. So, we're seeing essentially the same general rules from province to province, the same 27 weeks. Lining up with that EI entitlement. So, Chris, if you want to wrap up our formal presentation, and then we can get to some of the questions.
Yeah, so just really quickly, the next steps for all the attendees here as employers, I think that the first thing that you're going to want to look at is your leave and attendance policies, if you have them, to check for any gaps. So I think where you would specifically find gaps is potentially in terms of length of permitted leaves, requirements around medical documentation. Because again, in New Brunswick, all that's required or all that's required to take advantage of this leave under the Act is a medical certificate. And we're kind of used to sending these more robust questionnaires that go beyond kind of a medical certificate and may not be justified in every circumstance. I think that the other piece is that you're really going to want to take the time to train managers and people who are going to be approving and administering this leaves on what job protection means, on what reprisal risks exist, and really giving them a bit of a playbook on how to handle these if they come up and what they're required to do when the employee is ready to return to work. Again, you're going to want to standardize. This kind of goes back to the attendance policies. You're going to want to standardize how you deal with medical certificates. And you're going to want to be careful because, like I say, we're used to, if any of you have dealt with absences and accommodation and that, we're used to kind of these more robust questionnaires where the doctor provides detailed information. This is a very different leave, and this is a kind of guaranteed leave despite all that. And so you are looking at kind of lower thresholds for kind of the medical documentation. And then finally, if you're a unionized employer, check your collective agreement. I mean, we've got the Parry Sound decision that's going to automatically incorporate employment-related legislation or terms into your collective agreement. But you're also going to want to make sure that this leave still kind of fits with the other entitlements and rights that you're providing with employers. So the big thing is to just look through the documentation that you have right now, look through your processes and procedures that you have right now, and make sure that they align with this new leave.
I think you made a really good point there, Chris, which is that I think that the expected threshold of medical information that you're going to get as an employer to take this leave, to access this kind of leave, is going to be relatively low. But that doesn't mean you need to accept that kind of low level of medical information for the return to work process or for the accommodation process, where you really do very much need to understand what the employee's medical limitations are. So I think you have a much greater right as an employer in that return to work scenario, whether we're talking about somebody coming back from this leave or we're talking about somebody coming back from a course of LTD, and we're going to get into some of the questions around that, is that in order to be able to return this person to a suitable job, you need that kind of medical information. You need a higher level of medical information than I think you can require upfront to actually access these types of leaves. So you might get the one-line medical note, unfortunately, with employees looking to access these leaves, but that's generally not going to be enough medical information for the return to work process.
Yeah, agreed. So with that, I noticed that there's quite a few Q&As here in the Q&A panel. We received some questions beforehand via email, so maybe we'll go through some of those first, and then we'll tackle some of the ones here in the chat. We've got lots of time, and I think it's good because I think that's really more valuable than us sitting here kind of preparing our pre-can thing that may or may not be applicable to everybody. So the first question that we have that's been pre-submitted is, can you speak to the length of time when someone is off on LTD before you can replace a permanent position? And when can you terminate the employee from the company if you know that they're totally and permanently disabled? So I guess I'll tackle the second part of that question first, because that's a really sticky topic. So the general rule for somebody who's disabled is that their contract of employment becomes frustrated when they are permanently disabled and they're unable to attend work for the reasonably foreseeable future. And so this standard is really going to vary depending on the type of disability or illness or injury that the person experienced. There are going to be some disabilities that it's going to be readily apparent from the time it happens that they're never going to be able to return to work in the foreseeable future. And in those cases, it's very easy. But I think what most people on this call are probably dealing with at the moment is people who are off work due to mental disability. And mental disability is a little bit different and it's trickier to address because it is really cyclical. It's not a linear injury where somebody either is injured and they stay injured at that rate indefinitely, or they're injured and there's a very clear timeline for when they get better. It's often cyclical where employees will have periods where they're doing better, periods where they're doing worse. They'll have periods where they are recovering or appear recovering or appear to be recovered, and then there will be relapse. So it's very, very difficult to analyze. But in New Brunswick, what you're kind of looking at if you do want to terminate the employment for frustration in mental disability cases is somebody who's been off work for a significant period of time. And based on the jurisprudence that came out of New Brunswick, you're typically looking at somebody who's been off work continuously for a year and a half or 2 years before you can even start considering this. And then the second piece that you're looking for is that they're unlikely to return to work in the reasonably foreseeable future. And if you want to meet this standard, you're really going to need medical documentation. So you're going to need their doctor to put in writing that, look, this person is probably never going back to work. And once you've met those two elements, then you're in the realm of being able to discuss whether or not their employment has been frustrated. The other kind of piece that's added on top of this question is that this is talking about a person who's off work on LTD. So long-term disability, the way that the case law and jurisprudence kind of addresses this is long-term disability is actually an agreement between an employer and an employee, or an employer and a union if you're unionized, that does actually anticipate the person being disabled and being unable to return to work. And so the general rule with long-term disability and other benefits and entitlements that would be engaged when the person's disabled is that if terminating their employment would disentitle them to those benefits, you generally aren't allowed to terminate, even if you're at the frustration point, until those benefits have vested. So in this case, we're talking about an employee who's off work on LTD. Presumably the long-term disability benefits have vested, and the employee's right to claim them has been engaged, and the employee will kind of start claiming them. And so you're generally good in that situation to proceed with the termination if the contract's frustrated. Where employers get themselves into trouble is where the right to apply for those benefits has invested, and then the employer terminates anyway. That can become a big problem, because the way, like I said, the way that the courts are looking at this is they're saying, well, you provided long-term disability benefits. You obviously anticipated this particular situation happening, and so you should have given the employee the chance to kind of apply for and receive those.
Yeah,
Um,
certainly before you remotely consider termination of somebody who's on LTD, you've got to be talking to the LTD provider, reviewing your plan, and ensuring that the termination is not going to affect their eligibility to continue to receive the LTD benefits. Because if the termination is going to result in them losing that ability to access LTD, not only are they likely to sue you for wrongful dismissal damages, reasonable notice under the common law, et cetera, they're going to sue you for the loss of their access to LTD benefits.
which can get very expensive, because at that point, the employer can be in the position of being a self-insurer for those long-term disability benefits. So it can be very expensive. Alex, did you want to address the question of when you can replace a permanent position for somebody on LTD?
Yeah, I mean, so there's two pieces of this question I'm going to address, but the first one is, there are certain positions I think that you can make a very genuine argument that you're going to have undue hardship if they're not filled, immediately. You can't have an organization with no CEO in the long term, or you can't have an organization with no payroll person in the long term. Your other employees need to get paid. So, the expectation there, I think, is that particular position may need to be filled. That doesn't relieve you, though, of your obligation to review all of the possible options for that employee when they are ready to return under your duty to accommodate. So, finding the available position within the organization that's suitable to that person. Just because you've had to go and find a payroll person because payroll has to get done, doesn't mean that you can throw up your arms and throw up your hands when the employee is ready to return from that leave or from LTD. The other thing I wanted to address, obviously frustration. Lots of employers, they have employees who have been out for a long time. There's an information vacuum about the status of that employee. They're on LTD. We don't know when they're coming back. We don't know what their status is. I think it's very important to be checking in with that employee, whether it's a quarterly letter or every 6 months, especially for employees who have been out now for a very long time, to start gathering a prognosis of the reasonable likelihood of their ability to return. If they're just out there and you have no idea what's going on with them, it's hard to be able to defensively make the case for frustration without that medical information. And then the other strategic piece or tactical piece is that, at the end of the day, what you're really concerned about in a termination, in the context of somebody who's on a leave for disability or illness, you're concerned about, a human rights complaint, so discrimination, you fired me for a discriminatory reason. You're going to be concerned about, is this going to affect their LTD? So that's why it's very important to talk to the LTD provider, review your policy, make sure that you're not going to impact their sort of entitlement going forward to disability benefits. But then obviously in every termination, you're concerned about the wrongful dismissal claim. So the claim for reasonable notice or pay in lieu of reasonable notice under the common law. And so one of the ways that you can manage that risk is by giving notice of the frustration of contract. So if you send a letter that, if in a year's time there's no prognosis that you have a reasonable likelihood of return, we're going to consider your employment frustrated. So if for some reason you need to proceed with the termination, you try to provide notice of sort of when the frustration will occur, and you're giving the employee the opportunity to come back to you with medical information showing that they're able to return to work or when they're able to return to work. So you're not just out of the blue sending the employee a letter saying we're considering your employment frustrated as of today's date. I think you really want to give them every opportunity to show that they may be able to return to work in some fashion.
Yeah, and I think to kind of add on to that piece, as we've kind of discussed with leave, if somebody wants to take this long-term injury and illness leave, they're probably going to be able to access that by providing you with the medical note that says so-and-so is off work 3 months due to medical reasons. I'm sure everybody's seen that note. But that doesn't override your duty to accommodate, which is kind of linked to this and linked to this information gathering exercise that Alex is talking about. So even when an employee is on leave, on an approved leave under the Employment Standards Act, the duty to accommodate is still going to apply, and employers are still going to have an obligation to figure out if there is a way that they can return the employee to work and what accommodations they're going to need. So, in those cases, it is acceptable to ask for information on that. The only thing that wouldn't be acceptable in terms of these employment standards leaves is typically when we're dealing with accommodations, the way that we deal with them is to say, look, you have to provide us with this additional information. If we don't receive this additional information, we're not going to be able to approve your leave of absence. And, we may take steps to end your employment on that basis. In this case, you can't go to that point as long as they have access to this leave and as long as they're within their 27 weeks, but you can still ask, and you probably do have an obligation to ask those questions. One, under your duty to accommodate, and then two, if the employee is injured at work, under your duties and obligations under the Workers' Compensation Act. So just because an employee brings in a medical note and says, look, I'm going to be off work and I can't come back, that doesn't mean that you just stop talking to them, because you are going to have additional obligations and you are going to be required to gather additional information and show that you met the duty to accommodate. And that kind of brings me to, this is a good question that popped up in the Q&A bar here, where I think Christine says if somebody's on a very long-term leave and they're not being forthcoming with documentation to support their leave of absence, how long should we permit the employee to remain on leave past the expiration of the last medical note received? And so this is a really good question, and one that comes up a lot. And so I think my kind of commentary before this, look, if they're within that 27 weeks, you're going to have to wait until the end of that 27 weeks, even if they're not providing you with all of the information that you want. After that 27 weeks, you're into duty to accommodate territory. And the key thing for employers to remember about the duty to accommodate is that it is a double-edged sword. So employers have a duty to gather information, and they have a duty to assess accommodations and figure out what the employee needs to go back to work. But on the other hand, the employee has a positive obligation to provide you, the employer, with enough information so that you can do your job. And so in terms of Christine's question, kind of the typical approach is to send these follow-up questionnaires asking for additional information about what accommodations are required, what functional limitations the employee is experiencing, how long those are expected to last, et cetera, et cetera. And if the employee is not forthcoming with that information, now I usually, kind of the rule of thumb is to give them kind of 3 chances, 3 strikes, you're out. But if they won't provide that information, at that point, your duty to accommodate ends, because the employee has actually frustrated the accommodation process, and you don't have to approve their leave of absence. And since they're on an unapproved leave of absence, their options are either return to work, provide new medical documentation supporting it, or their employment will end. And that's perfectly acceptable. Again, provided you are outside of the time periods protected under the Employment Standards Act, and if the employee is injured at work, the Workers' Compensation Act.
Yeah, and I think that's one of the things that always comes talking duty to accommodate is that it is a two-way street, right? The employee has got to participate in the process. They've got to give you a foundation on which to accommodate. So they've got to give you enough medical information about their limitations that you can then design the appropriate accommodation or try to find the appropriate accommodation. So if they're not participating in that process, at some point that does frustrate the process. From the employer's perspective. And I think if there's one sort of key question to ask yourself, going back to the very first question that we had in the Q&A, when can we terminate the employee if you know they are totally and permanently disabled? The question you need to ask yourself is, how do you know? Because that's what you're going to be questioned on, whether you're at the Human Rights Commission, whether you're at the Labor Standards Tribunal, whether you're forward is, how did you know that that person was unable to work going forward or for the foreseeable future? So that's the medical information you need. That's why if you are going to go the route of frustration, I suggest that notice to the employee so they have an opportunity to supply you with information that might show whether or not they could actually return. So how do you know? That's an important question to ask yourself when you're evaluating these circumstances.
Yeah, absolutely agree. And then just to kind of add on to another point that Alex was addressing, and it seems to have come up quite a bit in the Q&A panel here and in some of the pre-submitted questions we received, is about backfilling the position of an employee who is off. And so there's really no issue with backfilling that position. You just have to be aware of your obligation to return that employee to the same or comparable position. And so what that means for employers is, look, if you're going to hire somebody to backfill that role, you're going to want to make sure that you have protections in place to make it easy to either get that person who's backfilling out or to get the person who's returning into a different role. And so what I normally recommend to employers is, look, if you're going to hire somebody to backfill a role, just make sure that you have a very strong employment contract and that you're upfront with the employee about the nature of what they're being hired to do. And so in some cases that might look, where you have a very clear timetable for return. It might look like a term employment contract, where the person's hired to backfill for a period of 6 months. Which is very strong protections, because once that contract ends, there's no entitlement to notice of termination or any of the other pitfalls that employers find themselves in. And if the timetable isn't clear, which in a lot of cases it isn't with mental disability and drug and alcohol addiction specifically, I usually just recommend that employers ensure that they have very strong termination clauses in their employment agreement, so that they can limit their financial exposure in the event that they do have to remove a backfilling employee to make room for the returning employee. And I think that if you structure it that way, and you make sure that your employment contract is kind of rock solid, you can really eliminate a lot of the risks that employers are concerned about when trying to backfill a position. So there's not like I said, there's not really an issue with backfilling positions if you need to do it. But if you do need to do it, you just need to make sure that you've taken the steps to protect yourselves. And then if you're dealing with a unionized environment, you're obviously going to have to go through your collective agreement, take a look at your job posting requirements, take a look at who kind of gets the right of first refusal on those positions, whether or not you've got transfer rights in your collective agreement. The analysis is a little bit different, but the key thing is to make sure before you do anything in a unionized environment that you're going through your collective agreement and making sure that you're not going to be offside that.
Yeah, we've got I've got a question at the top of the Q&A here. I'll refresh in a second, but I've got one here. If you're performance managing an employee and they're notified by the employee they'll be off due to medical leave, do you have to wait until they return to work to perform the performance management meetings, or could you do them virtually? I wouldn't do them while they're on leave. You're either going to have your disciplinary before they've gone off on leave, if they're giving you advance notice, or you ought to put in and wait for their return. You don't want to be in the circumstances of the employer of making their leave worse, the recovery worse. Performance management, it's difficult for the employee to hear, depending what they're going off for. If they're going off due to anxiety or depression, for example, I'm holding a virtual performance management meeting while they're off trying to recover, trying to get into the right headspace. That's not going to be helpful. I think from the employer's perspective, when you have somebody going off on these leaves, even if it is an employee who's had problematic performance or behavior, that you want to be in the position of being supportive to that employee, to try to get them to return to work, and being as helpful as you can in facilitating that return to work, and not sort of adding to the problems. It's an unfortunate reality that we all the time run into circumstances where an employee senses that they're about to be disciplined for something, or they may be terminated whether it's due to poor performance or whether it's due to insubordination or misconduct, and they go off on leave. That happens all the time. But it's better to put a pin in it, document it now, so you remember what the issue was, so that you have your talking points. Wait for the employee to return and address it, and reestablish expectations on their return to work.
And kind of an add-on here that I see that just came in at the top of the Q&A. How should we manage our duty to accommodate post-sick leave and the function of the role? For example, customer service role with the doctor's note requiring an accommodation of no customer interaction for 6 weeks. So when you're dealing with accommodation, and I'm cognizant that we don't have a lot of time here, and this is quite a can of worms, but when you're dealing with accommodation, there's really two components that you're going to want to look at. There's a procedural component, so how you actually carry out the accommodation process, and then there is the substantive process. There's a substantive portion of it, which is what accommodations you actually provide, or when you decide that the accommodation process is over. So I think that this question, how do you manage it? Well, you have to accommodate on the substantive side. You have to accommodate an employee to the point of undue hardship, which is going to vary from workplace to workplace, and is going to depend on your operations, interchangeability of your workforce, and that kind of thing. But generally, what you're looking for is an accommodation that will unduly interfere with your operation. So in this case, if there was a employee who had a customer service role, and they had a doctor's note saying, well, they can't do customer service actions indefinitely, and that was the only type of role that this employer offered, say it was a call center or something like that, well, then you've probably reached the point of undue hardship, because there are no accommodations that you can offer that will let that employee carry out the only duties that they could possibly provide. The other point that I think is kind of more important, and where employers kind of fall into getting kind of more trouble, is on the procedural side. So the duty to accommodate is a lengthy and it's an iterative process. And so employers have a duty to collect information. Employees have an obligation to provide information. And it's not enough to just make one pass at the situation. So it's not enough to say to the employee, okay, what do you need? And the employee says, well, I need X. And then the employer looks at that and he says, I can't provide that. So we're going to have to end the employment relationship. There is an iterative duty to go back to the employee and say, look, we cannot provide X, or we do not have medical documentation confirming that you need X. And so we're going to need more information on what's medically necessary. And we're going to need more information on alternate options other than X, because we can't provide it. And that process can go back and forth for a long time. It can be very frustrating. But if you don't go through the procedural step, you can be found, you can end up on the wrong side of a human rights complaint, even if, when we look at things objectively, accommodation was never going to be possible. In New Brunswick, the New Brunswick Labor and Employment Board has said a failure to meet the procedural requirements of the duty to accommodate is discriminatory in and of itself. So it's very important that when you're dealing with accommodating an employee post return to work, you're taking care of this procedural side, you're staying in touch, you're doing follow-ups, and only after you've done all this can you actually conclude that, hey, we aren't able to accommodate this disability.
There's a couple of questions here from Jackie. I'll try to answer them as sort of quick hitters. There's a question about prorating vacation if somebody's gone on leave. That's going to depend how you're handling vacation to begin with. So there's statutory vacation pay, which is presumably based on hours actually worked. So if the employee is not working, then they're not accumulating vacation pay, but their vacation time is still guaranteed under the statute. And then if we're talking about employees that have a vacation policy above that, so if you were as an employer vacation policy, you really have to look at that policy to figure out exactly what it says about entitlements to vacation while the employee is on leave. So a bit complicated question to necessarily answer, though. More facts there. There is a second question about if somebody is on leave and you're unable to contact them to discuss their return. Well, certainly when you're in these protected leaves that we've been talking about, the employee's job is protected while they're on this leave. The expectation is they'll return and have their employment. But when we're talking about somebody who's been out on sort of an unapproved leave, or out on a leave well past these protected leaves, and you can't get a hold of them, you can't find out when it's expected that they're going to be returned, they're not answering any of your requests for medical information, for example, then you're in a circumstance where you can begin to approach a concept called job abandonment, where, similar to frustration, you might say, if we do not hear from you within 3 months or whatever the period might be, we will consider you to have abandoned your employment. So if you're in that circumstance, that might be the approach there. Thank you very much, everyone, for your time today. I think so. We do very much appreciate you joining us today. I hope it was informative.
Yeah, thank you very much.